All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick.
And she's going like, what the hell?
Mr. Brooks, I'm reviewing this for completeness. And you have simply put on here, State of Wisconsin plaintiff. That's an entity. You have to name a person, sir. The date. Well, the date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the state, how could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
So he tries to call the State of Wisconsin to the stand. This is not exactly a common ploy, but I've seen it done before. And in my opinion, Judge Darrell and the prosecution handled this very badly. Let's watch some more.
Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the State of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not, or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And
I've always considered the plaintiff to be a civil court thing, but maybe in Wisconsin, in criminal trials, the state is considered a plaintiff.
why are they not able to testify, being that they...
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the State of Wisconsin. And with all due respect...
Sir, I believe your Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
Can you spot the problem with his argument?
Found after that point, there was an information that was filed. I'm not going to explain any further why you can't call the State of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record,
And I'm
Your
also,
Honor,
hold on, I'm also not going to issue a written decision on that. The record speaks for itself.
there's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor.
Remember, I'm asking you, what is the problem with his argument about facing his accusers?
When it's clear discrepancies in the paperwork of this matter.
The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you have been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
I would almost ask him, why are you asking me about an interlocutory appeal? And just post it back to him. Why are you asking me? That's an argument you make to the appeals court, not me. However, did anybody catch the mistake? Yeah, well, there's a logical problem with his deal, right? Once again, Mr. Brooks, you killed your accusers. Well, you can't say that, although we know it's true. They can't make it to court. That's not the problem. His argument is that the Sixth Amendment guarantees him the right to face his accusers. The Sixth Amendment doesn't say that at all. Let me read it to you. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Informed of the nature, okay? That's all you have to do is you have to inform them. To be confronted with the witnesses against him. Not the accuser, the witnesses. Okay, let's go ahead and read a little bit more here. The right, this is the Sixth Amendment, and this is findlaw.com, which is pretty reliable. The right to confront witnesses brought against them. I cannot understand why in the hell a judge and prosecution, by the way, they missed it too. Why didn't you catch the fact that he's misquoting the Sixth Amendment?